Hello, friends, welcome back. In this part of lecture regarding the ICJ. So, in this lecture, friends, there are very much important discussion I'm going to share with you. So, what are the criticism and what are the loopholes in the jurisdiction of the International Court of Justice? These are the points which are common criticism of the International Court of Justice. The International Court of Justice has been accused of being biased. Judges usually rule in favor of the states, which their own country looks favorably upon. Bias also plays a great role in voting for the president and vice president of the bench. The International Court of Justice can only rule on the cases where both the states have given their consent. Therefore, even if there is a case where the authority of the International Court of Justice is much needed, the International Court of Justice cannot do anything unless they get consent from the other states involved. Only states can seek recourse under the International Court of Justice, not organizations, private enterprises, or even individuals. Therefore, in the cases where minority groups are being exploited by their state, the individuals of these minority communities cannot seek the recourse under the International Court of Justice. There's only state can invoke the jurisdiction of the can knock the door of the jurisdiction of the International Court of Justice. No individual, no private person, no private enterprises or organization or minority groups of that state, if if there's any majority population or majority segment of the state do any human or injustices with the their minority group within the state, then ICJ cannot do anything. And other international courts like the ICC are not under the umbrella of the International Court of Justice. Therefore, conflicting opinions from the various international courts make it difficult for the international community to collectively enforce the peace. The International Court of Justice does not enjoy the separation of the powers and is sometimes at the mercy of the Security Council. Permanent member states can veto attempts to enforce the decision of the ICJ. For example, it means ICJ is not independent force. There is no separation of power because the decision of the decision of the ICJ has no any appeal, and when the decision becomes the binding on the state, they are not obeying, then the decision will come before the Security Council, and ICJ will take help from the Security Council to enforce its judgments and decisions. Then ICJ is on the mercy of the decisions of the Security Council, whether they will think deems fit or proper to enforce its decision or not. Even any permanent member of the Security Council can veto the decision of the ICJ. The implementation of on the decision of the ICJ can be vetoed by the permanent member, five permanent member of the ICJ. If let's suppose any state want to enforce their decision, likewise in conclusion, the other decision, Pakistan is not complying with the decision of the ICJ, then India will request the Security Council. Then the member of Security Council will decide or will do the pressure on the Pakistan authorities to comply with the decision of the ICJ. If China will veto that decision of ICJ, then Security Council will not act upon it, will not make direction to the Pakistan to comply with the decision of the ICJ. So these are the loopholes, these are the weak points of the ICJ, because ICJ is a judicial organ of the United Nations. ICJ has no any force to implement its decisions. ICJ will rely on the mercy of the Security Council. Then Security Council will decide or make it make it to get the fruit of the decision of the ICJ. That will depend upon the member states of the Security Council, and as well as the five superpower of the Security Council. They can veto to enforce the decision of the ICJ. And the cases where ICJ has failed to enforce the peace, like there's a very famous case where ICJ failed to enforce its peace, United States occupation of the Nicaragua, the Contra the Contra rebellion. I will also share this decision, this case with you as well. The Contra rebellion was a right-wing rebel group against the socialist group government of the Nicaragua. These rebels violated numerous human rights and used terrorist tactics to usurp the government. They have been accused of targeting health centers, kidnapping, torturing, and even executing civilians, some were children, raping and committing other sexual crimes against the women, seizing civilian property and burning civilian houses. Nicaragua stated that the American government had funded the Contra rebellion against the Nicaragua government. They were also accused of planting naval mines in their territorial waters. There was established evidence that the Contra rebellion was not only funded by the CIA but was also established by the Ronald Reagan's administration to fund the rebellion. The United States sold weapons to Iran and assisted the Colombian opium trade. Then the ICJ held that the US had grossly violated international law as well as Nicaragua sovereignty. Nicaragua asked for $17 billion in reparations. In response, the United States withdrew its support of the ICJ and, as a permanent member, vetoed any attempt to enforce ICJ's judgment. As earlier I said, the five superpower can veto any decision of the ICJ, and till this day, Nicaragua has seen no compensation is decided by the ICJ. So another the failed decision of the ICJ, that is the Israel and Palestine. Recently, the ICJ accepted the jurisdiction of Palestine. And there's very significant defining uh, act of the ICJ. I will also share with you these recent cases. One of the greatest violation of the international law has to be the West Bank wall constructed by the Israel that cuts through Palestinian communities, homes, and farmlands. Under the use of the protecting Israel against the terrorism, the wall goes deep into the West Bank, which is Palestine's territory. It seeks to redefine the borders by annexing Palestine, and thus is a grave violation of not only Palestinian sovereignty but international law as well. And 15 years ago, the ICJ had ruled through an advisory opinion that the wall was illegal. While such opinions are non-binding, they also said the wall violates international law and should be dismantled. It also stated that Israel should pay reparations, but such orders fell on deaf ears, and Israel was not willing to comply with the decision of the ICJ. The United Nations General Assembly tried to force Israel to cooperate, but that was a failure as well. Till the present day, the wall strangulates the West Bank, and present government continues to expand it, pretending like the ICJ ruling never happened. Which are current cases regarding the failure of the ICJ, the Rohingya genocide is a chain of prosecutions by the Myanmar government and the Buddhist community of the Myanmar against the community of the Muslim Rohingyas. The Myanmar military and police cracked down on the Rohingya Muslims and failed to check the growing Islamophobic sentiments against them. This resulted in thousands of Rohingya Muslims being killed, refugees fleeing to other countries, destruction of the Rohingya villages, schools, and business, wide-scale violation of the human rights by the military, and gang rapes and other sexual violence against the women and girls of the Rohingya community. Where also the it also shows the failure of the ICJ. Another case, the Gambia, the Republic of the Gambia had brought a case against the Myanmar for the Rohingya genocide. It was noted by the ICJ that thousands of Rohingya refugees were made stateless due to the state-sponsored violence. The court observed that the Rohingyas were a protected group under the Article 2 of the Genocide Convention. They stated that despite Rohingya Muslims living in Myanmar prior to independence, they were made stateless by the 1982 Citizenship Act and disfranchised in 2015 from the electoral process. The bench ruled that Myanmar must keep in mind the duties given under the genocide and ensures all acts of prejudice against the Rohingya Muslim are stopped. But recently, one of the Nobel Prize, Aung San Suu, she is the president. Now she is under the custody of the coup, which is happened recently. At that time, she was the president, and she pleaded the case in support of the army and other groups they did with the Muslims. So there are a lot of countries who acknowledge the Swiss, the acknowledgement of Swiss in order to restore the democracy in the Myanmar. And even as far as my information is concerned, even I think the Nobel Prize was restored from her. Whether it is true or false, I don't know. But a lot of the medals given to her has been restored by the many countries. Now she is under custody. Again, military dictators, they coup in the elected government, and now this day before yesterday, 38 protesters are killed in the tragic operations of the military coup in the Myanmar. And another failure of the ICJ and the United Nations regarding the Kashmir issue, which has been uh, since the independence of the Indian and Pakistan, which is disputed territory between the Pakistan and India, as UN charters and the United Nations also said that Kashmir issue can be solved with the charter of the United Nations, and now it has been past 1 year, more than 1 year. The Muslims are under the curfew. They are confined the homes. They are deprived of their basic rights. Even they cannot access internet or any other uh, communication channels. They can communicate. They can express. Freedom of expression is also banned in the Kashmir territory. But the United Nations and ICJs failed to give them their prestige to live being independent citizens over there. So these are the loopholes, these are the failures, the principles. On basis of that principles, ICJ and United Nations has been established, but there are a lot of loopholes. There are still reforms required. The question of biasness and impartiality, and especially with the Muslim in Syria, what happened in Syria when a lot of European countries, they stopped their refugees, they stopped taking refugees from stop their borders, and they didn't accept the refugees from the Syria. And when we saw the uh, very, you can say, in the history of human, we saw very tragic scenes over there when there's a picture emerged in the video of the world when a child is dying in the bank of the ocean. Then then those states they were sleeping, they opened their borders for the children, women, and the peaceful citizen of the Syria who were the uh, victim of the greed of the power politics which has been happening in the Syrian territory when the Daesh has destroyed the city of the old city of the Lab, which also called Aleppo, which was the one of the oldest cities, oldest civilizations in the mankind, and which completely destroyed by the terrorist activities of the Daesh and the fighting between the rebellion and the government of the President Bashar. And the role of the United Nations and ICJs failed over there. And another Muslim country, Libya, which is also suffering, and Iraq is suffering. The atrocities happened in Afghanistan, Iraq, Libya, and now Yemen, where people are dying with the hunger. When state is sponsored, the governments, the proxies, they are fighting for their supporters, their sponsored governments, and their allies. What they are doing, they are killing innocent peoples, they are destroying. There are a lot of millions people become homeless, and their peaceful life is disturbed over there. But United Nations and ICJ is failed to play their positive role for the mediation and to help the humanity over there. So there are a lot of other examples which can be discussed. The role of the United Nations and the role of ICJ for the purpose they have been established to avoid the conflicts which shock the human minds, which shock the human wisdom, and which helps to the humanity in order to better lives and harmony of the society. So, students, it was the brief and very comprehensive detailed discussion lecture on the creation of the International Court of Justice, its function and composition, the appointments of the judges, their terms. We have discussed the jurisdiction of the ICJ. There are three jurisdictions: contentious, advisory, and incidental. And contentious jurisdiction divided in three further jurisdiction. And there's one compulsory jurisdiction, which is when the member states come before the ICJ. The decision of the ICJ is binding upon the member states. And finally, students, thereafter, what what we have learned in this lecture, and where students, there's another very much important topic which we have left. That is the what is the comparison? What is the comparison? What is the difference? And what are the points which distinguish ICJ from the ICC? The feature of the first feature, the establishment of the code. ICJ was established, created in 1946. ICC was established in 2002. The language of the both courts are same, and the relation of with the United Nations. ICJ is the component of the United Nations and the created under the charter of the United Nations, which is the official code, the World Code of the United Nations, commonly referred as the World Code. But on the contrary, ICC is independent, may receive cases refers from the United Nations Security Council, can initiate prosecutions without UN actions or refers. Location of the both courts are the same, which is located in The Hague, the Netherlands, and the jurisdiction, which is very much important, million-dollar question, talk of the United Nations member states, that is the national governments of the jurisdiction of the ICJ. In the ICC, individuals, states are the jurisdiction of the ICJ. States can invoke, but individuals can invoke the jurisdiction of the ICC. And types of the cases: contentious, contentious between the party, advisory, and incidental. And in the ICC, there are six crime type of the crimes, which are criminal prosecution of the individuals, and subject matters of the ICJ is the sovereignty, boundaries dispute, maritime disputes, trade, natural resources, human rights, treaty violation, treaty interpretation, and many more. But the ICC can invoke his jurisdiction on genocide, crime against humanity, war crimes, and crime of aggression. And precedent: no stare decisis prior case law is a persuasive authority. Same, no stare decisis prior case law is the persuasive authority. And what are the funding resources? ICJ is funded by the United Nations, but the ICC depend upon the contribution from the state parties, organizations. Rome Statute will give the functions of the funding: voluntary contribution from the United Nations, voluntary contribution from the governments. And appeals: no appeal in ICJ. ICJ decision is an contentious case, is binding upon the parties. If a state fails to comply with the judgment, the issue may be taken to the United Security Council, which has the authority to review, recommend, and decide upon the enforcement. Appeals chamber: Article 80 of the Rome Statute allows the retention of an accused defendant pending appeal. The budget in $1 million of the calculation of the budget. So, student, was the comparison between the ICJ and ICC. So thereafter, what we have understood is, student, from this lecture, what we have learned that International Court, Criminal Court, and the International Court of Justice are two institutions that are focused on the human rights and humanitarian law. A court is form of the tribunal, often a government institution, wherein everything that goes beyond the law or human law will be in, wherein everything that goes beyond the law or human law will be investigated. Most of the time, people get confused with two courts as how they differ. They are almost the same in most cases, but the courts is how to the differ. They are almost the same in the most cases, but the only difference is their jurisdiction. If the country you belong is part of the United Nations, you can go directly to ICJ, and if you are not, go to ICC. For further proceedings, the ICC is based on the principle of complementarity. This means that ICC can only act when a national court is unable or unwilling to carry out a prosecution itself, because the ICC was not created to supplement the authority of the national courts. However, when a state's legal system collapses, or when a government is a perpetrator of heinous crimes, the ICC can exercise jurisdiction, whereas ICJ settles in accordance with the international law, the legal disputes submitted to it by the states, and to give advisory opinion on legal questions referred to it by the duly authorized international organs and agencies. And further, students, is the principal judicial organ of the United Nations. It is an important uh, facet for the promoting and the maintaining peace. The regularly host visit by the heads and dignitaries of states. It settled cases of the extreme international complicity in the less than 5 years. The court accounts for less than 1% of the United Nations budget. It is unique to the world. Through its judgment, opinion, and orders, ICJ lends its support to the United Nations so that it can achieve its primary purpose, which is to maintain, promote international peace and security. But despite having so much authority, it fails to achieve its purpose. In many cases, we have seen that countries do not comply with the rulings from the International Court of Justice. Therefore, despite being a giant in the world of international law, it seems to grow increasingly less influential on states and regulating its compliance with international law. So, students, I hope These learning give you enormous uh, knowledge on the uh, composition of the ICJ, and now you can uh, you can explain the role, function, and jurisdiction of the International Court of Justice by listening, watching, understanding this lecture. Thank you very much, students, for your patience. And after this lecture, there will be a very much important lecture I will give you. There are two jurisdictions: the compulsory jurisdiction of the ICJ and complementary jurisdiction of the International Court, International Criminal Court.